Hello friends, welcome back. In the last session, we learnt about the settlement of issues by the court in civil suits. Okay friends, Order 15 speaks about disposal of suit at the first hearing. Order 16 speaks about summoning and attendance of witnesses in civil suits. And Order 16A speaks about summoning and securing of the witnesses confined or detained in the prisons. Okay friends, Order 17 deals with adjournments when the suit reaches to the stage of trial, whether the courts can grant adjournments or not, etc., are dealt with by the provisions of Order 17. Okay friends, Order 17 strictly speaks that not more than 3 adjournments shall be granted. Okay. Rule 1 of Order 16 says that within 15 days from the date of settlement of the issues, the party shall file the list of their witnesses before the court. Okay, but nobody is doing so. That is for the purpose of trial, but nobody practically doing so. Friends, now we are coming to the main aspect of civil litigation, that is the trial of civil suits. Okay, friends, Order 18 speaks about hearing of suit and examination of parties. Okay, and Rule 1 says about the right to begin. For instance, if the plaintiff asserts a right, he has to begin the trial. Or if the defendant, in the circumstances of the case and by his additional pleadings or facts, denies that plaintiff is not denies or alleges that the plaintiff is not entitled to the relief claimed, then the defendant will get the right to begin the trial. Okay friends, this is Rule 1. Who shall begin the right? Who shall begin the trial? Okay friends. And Rule 2 of Order 18 says that the party who begins the trial who shall submit his statement of evidence and evidence before the court, and the other party shall then adduce his evidence, and both the parties are at liberty to submit their oral arguments, and they can also submit the written arguments, but the court shall not grant adjournment for filing the written arguments. Okay friends, and the court shall fix time for submitting oral arguments for both the parties. That is Rule 2. Okay friends, actually the arguments shall come at the last stage before the passing of decree or pronouncing the judgment. But Sub-Rule 3 of Order 2 of Order 18 speaks about the oral arguments and written arguments. Okay friends, Rule 3 of Order 18. Rule 3 of Order 18 says that when there are several issues, where there are several issues in a suit and the burden of proof lies on the other party on some issues, the party beginning the trial may adduce evidence on all issues, or the party beginning may reserve its right to adduce his evidence as an answer to the evidence to be adduced by the other party on whom the burden of proof lies in respect of some issues. Okay. In short, the parties can adduce evidence one by one, or alternatively, first plaintiff, then defendant, then plaintiff, then defendant, or first defendant, then plaintiff, according to their burden of proof. Okay friends, this is Rule 3. Rule 3A of Order 18 says that the party examine himself as witness in this suit on his behalf, but with the permission of the court, he can examine himself at a later stage as a party of his own case. Okay. Normally, the party shall examine himself first. For instance, if I am the plaintiff, I shall be examined as PW1 first, and then my other witnesses, attestants, etc., my neighbors as PW's plaintiff witnesses numbers 2, 3, 4, etc. So also DW1 defendant has to examine himself first. but with the permission of the court, he can examine himself as DW2, DW3 or DW4, etc., etc. Okay, friends. Rule 4 of Order 18 says that examination in chief shall be an affidavit, and such copy shall be furnished to the other side. That means before the introduction of this rule in Order 14, the examination in chief of a witness will also be taken in the open court, but that was dispensed with, and the examination in chief of witnesses of parties can be filed on affidavits before the court. Okay, friends. While filing affidavit, the parties shall put up their evidence, like I submit that I am the owner of this property, or I submit that the defendant known to me and he borrowed a sum of rupees so and so from me, like that. And last, in the at the end of the affidavit, he shall mention the documents, list of his documents which are proposed to be admitted into evidence or which are proposed to be marked by the court. Okay, friends, this is the, and lastly, he shall verify the affidavit, like solemnly affirmed and signed before me on so and so at so and so Vijayawada, so and so, like this. Okay, friends, this is a rule for affidavit shall be like that. Okay, friends, and when once the affidavit is marked and the witness appears before the court to face the cross examination by the other side, he shall verify the contents of the chief examination affidavit. Normally, the judges will do that. Judges will ask the witness, do you know the contents of your affidavit? Are they true? Then he need to say yes. Okay, that statement will be recorded by the judge in his affidavit, deposition. Okay, friends, so deposition is called chief examination plus cross examination together is called the deposition of a witness. Okay, here we are dealing only with examination in chief. Normally, the chief affidavits are filed like that. Chief affidavit in lieu of examination in chief of PW1 filed under Order 18, Rule 4 of CPC, like that. Okay, and thereafter the cross examination of the witness begins. When it comes to cross examination, the provisions of sections 137 to 165 of the Indian Evidence Act 1872 relating to chief examination, cross examination, re-examination, what questions to be asked, what questions not to be asked in the cross examination, previous statements can be asked in the cross examination, witness can be challenged regarding his character, etc., etc., deals from sections 137 to 165 of Indian Evidence Act. Of course, the Indian Evidence Act has been replaced by new law. We will discuss later if the next topic relating to the Evidence Act. Okay, friends, and soon after the chief examination affidavit is filed before the court has to mark the documents relied on by the party who is being examined as a witness. Okay, friends, at the time of marking documents, you being a lawyer of the other side shall oppose the documents if those documents do not conform to the provisions of law. For instance, my dear friends, a promissory note is insufficiently stamped and it is being proposed to be marked as Exhibit A1 in the cross examination. You shall object that properly the promissory note was not stamped properly, therefore it is inadmissible evidence. Okay, friends, and likewise an agreement of sale is filed which says that possession has already been given to the party plaintiff. Okay, and the plaintiff proposes to mark the document. You being the advocate of the defendant shall oppose that it cannot be marked because it is insufficiently stamped. And for example, A files a suit for permanent injunction basing on a partition deed among himself and his brothers, and he proposes to mark that document. Partition deed is compulsorily registrable under the provisions of Section 17 of Indian Registration Act 1908. It is not registered. Then you shall to take an objection that it cannot be marked because it is not registered and it is not valid in the eye of law. And the other side or the court may decide that under the proviso to section 49 of the Indian Registration Act 1908, this unregistered partition deed is admissible in evidence for collateral purpose, not for the purpose of main purpose. Partition deed is executed usually for the to show that the parties have partitioned their properties. Here, he wants to, in a suit for permanent injunction, he wants to show to the court that he is in possession of his share. That is collateral purpose, collateral transaction. For that purpose, that document is admissible in evidence. However, you need to take objection. It is for the court to decide that objection. Likewise, when you take objection that the promissory note or agreement of sale were not properly stamped, the court will decide the same. Under section 33 of Indian Stamps Act 1889, the court will impound the document, and the advocate who is proposing to mark the document may ask the court to impose fine of 15 times under section 35 for the deficiency of the stamp on the promissory note. Okay, friends. For instance, Schedule 1 of the Indian Stamps Act, under Article 49, the amount to be stamped on this promissory note has been explained. And if that is insufficient or not at all paid, then you can raise the objection. Then the court under section 35 of the Indian Evidence Act either itself impose fine, or it can send the document to the district collector or the district registrar for collecting the insufficiently stamped duty and penalty, which is 15 times. Okay, friends. Likewise, for example, Schedule 1A of the Indian Stamps Act pertains to each state. Each state has incorporated a schedule which is called 1A. Schedule 1 belongs to the central government. Schedule 1A belongs to the state government. For example, in Andhra Pradesh, under Article 47A of Schedule 1A of Indian Stamp Act, it is mentioned how a sale can be charged with stamp duty. And explanation to this Article 47A of Schedule 1A says that when a agreement of sale witnesses the delivery of possession, then it is a sale, and the stamp duty shall be collected as if it were a sale. In such cases, on the objection of the counsel for the defendant, the court shall impound the document under section 33 and shall send the document to the district registrar or district collector, as the case may be, to collect the stamp duty. When the court collects the stamp duty and penalty, it has no discretion. Therefore, the courts usually send documents to the district collectors or the district registrars who have discretion to minimize the penalty. Okay, friends. And section 36 of Indian Stamp Act says that when once the document is marked despite the fact that it was insufficiently stamped or it was not stamped at all, then it cannot be called in question at the subsequent stage of the suit or proceedings. And the remedy is only under section 61 of Indian Stamp Act. Okay, friends. Okay, you take the objection. Further, friends, the court shall determine or decide the objections with regard to insufficiently stamped documents or unregistered documents shall decide the same instantaneously. The decision of the court can't be postponed on these two aspects. The court has to decide on the bench itself before the advocates of both the parties himself. If any advocate is aggrieved, he would go for a revision. Okay, friends. These are the marking of documents and other objections regarding it is a certified copy. Original was not produced despite original is in possession of a party. Like that, if other objection, it is a Xerox copy, and such objections may be decided at the time of delivering judgments. But these two insufficiently stamped documents and unregistration of the document which is compulsory registrable, these questions shall be decided instantaneously on the spot. They can be postponed. Okay, friends, these are the marking of documents. Cross-examination. Rule 19 of Order 18 says that for the purpose of cross-examination, instead of recording the cross-examination in the open court, the courts can order commissions under Rule 4A of Order 26 for regarding the cross-examination of the witnesses, that is deposition. Already under Rule 4, the witness had already filed examination in chief by way of an affidavit. And what remains for the commissioner, advocate commissioner, to record the cross-examination of the, to mark the documents and to record the cross-examination of the witness. Okay, friends. And during the course of cross-examination, when the opposite advocate who is cross-examining the witness may request the court to record question and answer of the witness for the benefit in future, for the benefit of future, so that he may. Normally, the cross-examination is recorded in a statement, sentence-wise statement, not by question and answer way. It is recorded. A question is asked to the witness, and witness gives that answer, and that answer recorded by the court in a sentence. Okay, not by question and answer. Question and answer are recorded so that the appellate courts may see the demeanor of the witness or the conduct of the court. Okay, friends. And Rule 11 of Order 18 says that when an objection is raised regarding a particular aspect, the court shall record the question plus answer given, question posed by the advocate cross-examining the witness, and the answer given by the witness, and the objection raised by the other party, and the decision made by the court on that issue, in allowing that objection. Okay, friends. Order 17, Rule 17 of Order 18 says that the court may recall and examine any witness who had already been examined. Okay, friends, that is Rule 17. Rule 18 says that the court may inspect any property or thing which is the subject matter of the suit. Normally, the advocates seek indulgence of the court to appoint an advocate commissioner to inspect the subject matter property or subject matter thing, etc., etc. But this Rule 18 of Order 18 authorizes a judge to inspect the property himself. Okay, normally no judge will do that, but in certain cases there are certain judges who have done it for proper adjudication of the dispute between the plaintiffs and the defendants. Okay, friends. Sections 67 to 73 of the Indian Evidence Act 1872 deal with the aspects of proving the documents. The documents, like if you want to prove an attestable document, how you should prove it. If you want to prove an unattestable document, how you prove it. If the other side disputes its signature, how you prove it. Everything has been mentioned in these sections. And in the cross-examination of the witnesses, you shall also take the help of these provisions to put questions to the witnesses that your case is genuine. And these sections also advise you as to who should be examined to prove your documents. Okay, friends. For instance, a will is an attestable document. How a will can be proved has been mentioned in these provisions. Okay, if one person disputes its signature, how the document should be proved has been mentioned in these documents. And even Section 73 of Indian Evidence Act 1872 suggests that the court may compare the signatures or handwriting of the disputed handwriting to come to a just conclusion. You can invoke Section 73 of the Indian Evidence Act provision also for just adjudication of the case. And regarding the cross-examination, you should always be in a position to compare the pleadings of both the parties and evidence of both the parties and the documents, and you should cross-examine the witnesses to support the case of your client and to destroy the case of the witness. Okay, your cross-examination should be in such lines, and you will not learn the cross-examination, how to conduct cross-examination overnight. Over a period of time, when you see the senior advocates cross-examining the witnesses in the courts, you will gradually learn the art of cross-examination. Okay, friends, that's all for now. Thank you.